Debate, the honourable member for St. Paul's.
Mr. Speaker, as we have made clear throughout the process for S-2, the Liberal Party does not question the need to address the legal gaps and other problems surrounding the family breakdown for First Nations living on reserve. But the political rhetoric of this government members regarding this bill has been absolutely shameful. It is reprehensible for the minister to stand in this House and say, I know opposition members do not care about Aboriginal women and children, but we do. This partisan approach, simplistic approach, is completely against what the members on this side are objecting to. This problem will only be solved in a holistic way, and if it is in keeping with the advice of First Nations leaders and organizations and First Nations women themselves. The truth is that this bill will not effectively deal with the problem of matrimonial breakdown on reserve and fails to provide First Nations with the tools to implement appropriate measures for families to resolve disputes safely in a culturally appropriate way. Furthermore, the assertion of the government that the bill is the answer to the disproportionate levels of domestic and other violence against Aboriginal women is appalling. It's patently dishonest for the Minister of Status of Women to stand in this House and claim emergency protection orders alone will save lives. The fact is that the government's decision to move forward with this legislation without dealing with the issues of access to justice and gaps in enforcement capacity could actually make matters worse. When Mr. David Langtree, the acting Chief Commissioner of the Canadian Human Rights Commission, testified before the Status of Women Committee, he asked parliamentarians to consider three fundamental questions. First, will the proposed legislation provide women with fair access to justice? Second, will the proposed legislation ensure that women will be able to access their rights in a safe way? And third, do First Nations communities have the capacity they need to develop and implement their own matrimonial real property systems? Although I would broaden the questions to include First Nations men, I believe answering these three questions provides an ideal framework to analyze S-2 in both its scope and effectiveness. As one reviews the limited evidence the House of Commons Committee was willing to hear, experts who testified before the Senate and the many stakeholders who have provided comments outside the committee process, the answer to all three of these questions is a resounding no. The government's own ministerial representative on matrimonial real property on reserve, Wendy Grant-John, noted in her report, quote, the viability and effectiveness of any legislative framework will also depend on necessary financial resources being made available for the implementation of non-legislative measures, such as programs to address land registry issues, mediation, and other court-related programs, local dispute resolution mechanisms, prevention of violence programs, a spousal loan compensation fund, and increased funding to support First Nation communities to manage their own land. She went on to say, quote, without these kinds of supports from the federal government, matrimonial real property protections will simply not be accessible to the vast majority of First Nation people. The Liberal Party is very concerned that the government disregarded her advice and that of First Nations from across the country and brought forward legislation without these non-legislative supports. The
solutions available under provisional rules, which were imposed under this Act, rely heavily on access to provincial courts.
Many First Nations communities are in areas with limited access to courts or lawyers, and provincial courts may not be financially or even physically accessible for many First Nations individuals. Michelle Odette, president of the Native Women's Association of Canada, put this issue into context when she told the committee, Canadian women find it difficult to access justice because of the high costs involved, or in the case of those who live in remote areas because of the long distances to be traveled. So imagine what it's like for women in our Aboriginal communities. It is even worse. She went on to say, Quote, "It would be difficult for a woman who lives in a remote community such as Attawapiskat or in other communities in other provinces, such as in Quebec, to find a lawyer who knows family law and the Indian Act. The persistent underfunding of legal aid systems across Canada have left them ill-equipped to deal with current demands. It is clear that they will be unable to deal with the additional burdens of the unique legal and cultural realities of property division on reserve.
The lack of experience and understanding will also be a huge challenge for the provincial court system.
To mitigate these issues of access and cultural sensitivities, we heard time and again about the importance of the availability of alternative dispute resolution mechanisms in First Nations communities to deal with matrimonial breakdown. Yet there is no commitment to provide funding for alternatives to the court system, which would be more cost-effective and culturally appropriate. The
government has no comprehensive plan to deal with all of these facts, which will deny First Nations individuals practical access to the legal rights the legislation claims to give them.
In terms of responding to violence against Aboriginal women. As noted earlier, they have emphasized that this legislation provides for emergency protection orders for women living on reserve and claim this will save lives. Unfortunately, the government's decision to move forward with legislation without non-legislative supports may do the opposite for many First Nations women. Regional Chief Jody Wilson-Raybould addressed this in her testimony when she said, "Preliminary research we have uncovered shows a correlation between increased harassment and threats of violence against women who file for protection orders in instances where there are issues with their enforcement. We question the capacity and ability of such orders to be effectively enforced, particularly in remote communities with limited access to police services." Cette citation révélatrice doit être vue.
This revealing quote has to be seen in the context of the lack of funding for First Nations police forces and their unequal presence in many communities.
To First Nations and Inuit police forces and the communities they serve by providing a longer-term funding agreement, it is clear that the government is still not providing these essential services with the resources they need to do their job. In other communities serviced by the RCMP or other police services, there is often an inadequate police presence, and enforcement of existing laws is an ongoing challenge for these overstretched officers. Beyond issues around adequate enforcement, the bill also fails to address the root causes of family breakdown and domestic violence, namely the lack of housing, inadequate funding for child welfare, and inadequate access to legal aid and other services for Aboriginal women. For example, only 41 shelters serve more than 630 First Nation communities in Canada. And even Betty-Anne Lavallee,
President of the Aboriginal People's Congress, recommended to the Senate that this legislation deal with the urgent housing needs for victims of domestic violence. A recommendation that the government obviously chose to ignore.
We are concerned that many First Nations do not currently have the capacity to develop their own rules around matrimonial property and will be left with the provisional rules for an extended period of time. That means communities will have provisional rules that do not reflect their traditional laws, cultures, or realities imposed upon them without the time or the capacity to move beyond them. The government cuts to the National Centre for First Nations Governance, tribal councils, and other institutions focused on building First Nations governance capacity is further undermining the ability of First Nations to develop and implement such a regime. The government talks about a promised centre of excellence, which will help First Nations develop rules of their own, but this will not be up and running until after the passage of the bill and likely after the time frame allocated to most First Nations to develop their own rules.
There will be a window of only 12 months for First Nations to develop and adopt their own rules around matrimonial real property on reserve before the provisional rules are imposed upon them.
All the testimony we heard on the issue suggested this was a completely unrealistic time frame. The legislation that brought First Nations communities under the jurisdiction of the Canadian Human Rights Act provided a 3-year transition period. We heard from the Canadian Human Rights Commission that in their experience, that period may not even be enough, but would be more realistic. The First Nations Land Advisory Board had more than 10 years of experience facilitating First Nations lawmaking for matrimonial real property rights on reserve, and they made it clear that they are, quote, concerned about the potential impact of the proposed legislation on the 68 First Nations that are presently waiting to become signatories to the framework agreement and the other communities across Canada, end quote. They go on to state, quote, successful enactment of these laws by framework agreement signatories has invariably been the culmination of a multi-year community-driven consensus-building process, end quote. The AFN has also suggested 36 months would be a more appropriate transition period, and that is the time provided in this very Bill to First Nations in the First Nations Land Management Act process. Given current capacity issues and the fact the Centre of Excellence will take time to develop, it was clear that all First Nations should have the benefit of a consistent 36-month transition period to develop their own culturally sensitive matrimonial property regime, but this government refused even that common sense amendment. Although general public discussions were held on First Nations matrimonial real property in 2006 to 2007, it is important to note that both AFN and NWAC, the two First Nations organizations the government engaged to facilitate those meetings, oppose this bill. Consultation requires both a substantive dialogue and for the government to listen and, when appropriate, incorporate what they hear into the approach. The Native Women's Association of Canada and the AFN have been clear that they are not confident that the legislation will resolve the problems associated with matrimonial real property on reserve, and pointed out that the current bill fails to address many of the recommendations repeatedly raised each time this legislation has been brought forward. Further, given the recommendations of the government's own representative and First Nations about the need to deal with capacity and resourcing issues before, or at least in concert with, legislation, it is curious why the government decided to introduce this bill in the Senate, where it is subject to increased restrictions on incorporating resources.
As a Senate bill, this legislation cannot have financial implications.
Then, despite the fact that the legislation was introduced in the House of Commons on behalf of the Minister of Aboriginal Affairs, the bill was sent to the Status of Women Committee to be pushed through with only 2 weeks of witnesses.
This bill deals with legal and cultural problems related to First Nations, both men and women.
Inappropriate, too, for reasons of expediency, have the study of these complex matters done by a committee with no prior experience with Aboriginal issues. The fact the committee did not allocate reasonable time to hear from organizations with the expertise and experience to highlight some of the challenges was particularly disappointing. The AFN and the First Nations Land Advisory Board had less than 20 minutes of committee time, and NWAC was allocated 8 minutes. The Conservative majority then pushed this flawed bill through the committee without accepting a single amendment. This is not the way to produce effective and well-thought-out legislation. The Liberal Party will not be supporting this legislation because the government has decided to move forward in a way that not only ignores many of the fundamental issues at stake, but actually may make things worse. Thank you, Mr. Speaker.